If you take nothing else away from my remarks today, please hear this. In my experience, forced arbitration in the employment setting poses such a threat to workers' ability to vindicate their rights and to our system of common law that congressional action is required. The justification for forced arbitration is predicated on myths, on fictions about how arbitration is a good thing for workers, and we've heard many of those today. I want to address a few of them. Myth number one, forced arbitration reflects actual consent and is a negotiation between similarly positioned parties. This is not true. On the one side are well-resourced corporations, on the other are individual workers who must commit to arbitration before a dispute has arisen. Pre-dispute, workers often can't appreciate that eventual claims will be decided in confidential and individualized forums with restricted discovery and limited appellate review before a decision maker often selected by the employer. There are places that binding arbitration in the employment setting may make sense. Where it is the product of negotiation between parties of equal bargaining power, and that's where this piece about unions and employers, where the union wields the authority of the collective of workers as well as substantial experience. That's not the case in most forced arbitration, as Ms. Perez's story tells us. Moreover, in my experience, forced arbitration burdens those who are already marginalized: hourly workers, women, Black workers, and workers of color. Myth number two, forced arbitration is speedy. Consider one of my ongoing cases, a sexual harassment case filed in 2008. It has already gone through 4 appeals of the arbitrator's decisions, and we still haven't made it to trial. This is because many arbitration rules permit appeals as a matter of right where there would be no such option in court. In our case, the appeals included challenging the arbitrator's interpretation of the arbitration agreement to permit my clients to even seek class certification, a step that doesn't exist in court at all. These years-long appeals are ironic. Arbitration was heralded as an opportunity to free up the courts, but evidence suggests that courts are increasingly dealing with litigation about arbitration. Finally, myth number 3. Forced arbitration does not impede the effective vindication of rights. The truth is that forced arbitration does just the opposite, by deterring workers from filing claims to vindicate the rights granted to them by Congress. Forced arbitration provisions often include joint action bans, or as employers like to call them, class action waivers, which prevent workers from being able to proceed together, even when their claims challenge identical workplace misconduct. In my experience, the ability to conduct discovery and distribute costs to advance the shared claims of many workers at once makes those cases possible. Barring class and collective actions makes it nearly impossible for workers with smaller claims. And while mandatory arbitration in employment with adequate guardrails post-dispute may sometimes make sense, I cannot, as I sit here, envision a situation where bans on joint action ever do. Employers' own statements confirm that their primary concern is preventing workers from joining together. Indeed, some companies have announced their decision to end forced arbitration only for individual sexual harassment matters, acknowledging that it impedes accountability. If ending forced arbitration is the right thing to do, as one company put it, for individual sexual harassment claims, why are systemic discrimination claims any different? Joint action bans also cause inefficiency and inconsistent outcomes, whereas class and collective actions can only proceed where a court agrees that the claims can be fairly and efficiently adjudicated together and that class counsel is experienced. Joint action bans apply categorically, requiring serial litigation of the exact same issue. Claims that might have been adjudicated together in a single action are instead decided many times over, risking inconsistent outcomes. Finally, forced arbitration undermines our system of common law, by which judges author opinions that are subject to scrutiny. Forced arbitration is typically confidential. Matters of public consequence are hidden from sight. I was heartened to see in Mr. King's testimony that he agrees the secrecy in which forced arbitration is shrouded is alarming and should be prohibited. Moreover, arbitral decisions are not precedential. There is no notion that today's decisions must flow from yesterday's. The Supreme Court has described forced arbitration as nothing more than a change of forum. In reality, moving employment claims from the courthouse to a conference room fundamentally changes the playing field. creating a system of secret decisions that lack protections and undermine the integrity of our legal system and the atrophy of common law.
Ms. Kotagal, maybe you can talk a little bit about just the difficulty that employees have with discovery. Ms. Perez talked a little bit about this.
Yeah, absolutely. Thank you. So the thing about proceeding along discovery in arbitration is that the rules, the federal rules of civil procedure, the federal rules of evidence, the tools that we use to shape the discovery that we ask for are sometimes not present. And then the second piece of it that I think is really important is that where you are forced to proceed on an individual basis, you have access to less discovery. The rules of so-called proportionality in discovery mean that even if Ms. Perez were the victim of a pattern of discrimination at the company, she wouldn't have access to evidence showing that. And so those limits that on what you can get as an individual trying to understand where your situation fits into the company's policies are tremendously significant.